This is a recording of the Connecticut Veterans Legal Center's intermediate level VA benefits training that occurred on October 16th, 2015. You will hear from CVLC's Executive Director Margaret Middleton and Attorney Millie Vandenbroek, as well as guest presenters Christine Clemens and Dr. Madeline Baranowski.
It is my great pleasure and delight to welcome and introduce to you Christine Clemens, who is going to give us a presentation today on an advanced set of topics in VA disability law. I first met Christine when I had just started at CVLC about 7 months ago. I went to a New York State Bar Association event with Christine. And we heard Christine speak, and I was really impressed by her command of VA benefits law. And in addition to that, she has a long-standing commitment to serving the homeless population. She started off her career after graduating from the University of Michigan with a JD and a master's in policy. She started off as an Equal Justice Fellow at Public Counsel in LA and spent many years working in Southern California doing outreach and legal services for homeless people in Southern California, and out of that started to come in contact with a lot of veterans and developed an expertise in working veterans issues. She's now at Finkelstein & Partners in New York and specializes in VA disability appeals. And is going to kind of take it to the next level with topics that you don't typically hear about in depth in the online PLI type format that we sent out to all of you, those CLE training seminars. So she's going to talk a lot about topics that may come up in the cases that you see because they pertain often to the clients that CVLC works with who have mental illness and are living in poverty. So thank you, Christine, for being here. Please help me welcome her.
Thank you. That was a much better introduction than I could have done for myself, so thank you. And let me just say my contact information is here. If any of you have any questions about what I covered today or any of the cases that you're working on, specifically if they're related to disability compensation questions, you know, the best work that we can do is to promote competency in this area, and that's a big part of my mission. So, any questions? Please give me a call, email me. I'm happy to help you think through ideas on your cases, and I truly mean that. So today, this presentation will hopefully cover some issues that you may see. The first few topics I'm going to talk about have to do with, I'm going to talk about the presumption of soundness, presumption of aggravation. Those are going to be applicable potentially in your disability compensation cases. Clear and unmistakable evidence relates to that. And then clear and unmistakable error we'll talk about, it could relate to a pension case as well. If at any point I'm talking about something, I'm using terminology that you don't understand, just stop me and ask, because there's probably somebody else in the room who has that same question. So just a recap of the basics. Service connection for compensation requires medical evidence of a current disability, evidence of a disease, injury, or event coincident with military service, and a link or nexus between the current disability and the in-service disease, injury, or event. Now you hear this word a lot in the VA world, you hear about presumptions, okay? And that word means a lot of different things. Usually when we talk about presumptions, we're talking about presumptive service connection, okay? So, for veterans with tropical diseases, former POWs, veterans with exposure to Agent Orange, or other herbicides, Persian Gulf War veterans, chronic diseases. These are all presumptions that come up a lot related to service connection. That's not what I'm going to talk about today when I'm talking about presumptions. These other two presumptions are important for you to be aware of, the presumption of soundness and the presumption of aggravation, because certainly one, if not the other, will apply in any disability compensation case. Okay, so first we're going to talk about the presumption of soundness. What is it? How many of you have heard of the presumption of soundness? Okay. So the presumption of soundness essentially says every veteran taken and accepted, when examined, accepted, enrolled for service, except as to defects, infirmities, or disorders noted at the time of the examination, acceptance and enrollment, or where clear and unmistakable evidence demonstrates that the injury or disease existed before acceptance and enrollment was not aggravated by such service. Okay, what does that mean? It means if there's no pre-existing medical condition documented at the time of induction, okay, or time of entry into service, a veteran is presumed to have been sound in every respect. In other words, if it wasn't noted at the time of entry, you're presumed to have gotten it in service if it's noted at the time that you're discharged. Okay? The caveat to that is that the injury or disease was not caused by the veteran's own willful misconduct or abuse of alcohol or drugs. Okay. So an example of this, a veteran injures his knee during a training exercise in service. Over the next few years, his knee buckles a number of times and he sustains several falls. He injures his back on a fall. No conditions, injuries, or disabilities are noted on his induction physical. So, does the presumption of soundness apply in this case? Yes. Yes. Okay. Yes, it applies. Nothing noted at the time of his induction physical, at the time of entry. He injures his knee during a training exercise during service, and he continues to have issues with his knee. So, the presumption of soundness would apply to his knee. What else might it apply to? His back, right. Okay. Any questions about that? I'm going to talk in a minute about how to rebut, or how the VA can rebut the presumption of soundness, but that's the basic, those are the basics of what the presumption of soundness is and when it applies. Okay? The presumption of aggravation is where a veteran has a pre-existing injury or disease that's noted at the time of entry. So, essentially, if there's nothing noted at the time of entry, presumption of soundness. If there's something noted upon entry, it might be the presumption of aggravation, although there may be an argument that, depending on the type, so with the knee, for example, I've learned a lot about the knee joint, and there are apparently 3 different aspects to the knee. If you have an issue with one part of the knee, but not the other 2, and later in service you develop an issue with one of the other 2 parts of the knee, you might be able to make an argument that there was no pre-existing condition as far as the other 2 elements. It gets a little bit complicated. Okay, so presumption of aggravation, something's noted at the time of entry. It has to increase in disability. Okay? The other thing is there has to be a finding that the increase of disability, there cannot be a finding that the increase in disability is due to the natural progress of the disease. What does that mean? Does anyone have any ideas on what that might mean? Yeah?
If you have a degenerative disease, it's going to get better whether or not you're in the military. That's probably a pretty good example.
Right. So if you have a degenerative condition, it's going to degenerate over time, normal wear and tear. And the VA can show that this is just part of the natural progress, or the doctor says it's related to the natural progress of the disease, then that wouldn't constitute aggravation. Aggravation has to be something happened to hasten or to worsen that disability. Okay? Now, both of these presumptions can be rebutted by clear and unmistakable evidence. And I'll talk a little bit about what that is in a minute, but we'll first go to an example. Very similar to the first example. The veteran injures his knee during a training exercise in service. Over the next few years, his knee buckles a number of times and he sustains several falls. He injures his back on a fall. The veteran's induction physical notes that prior to service, the veteran injured his knee playing high school football, but was otherwise fit for full duty. Okay. This is actually a questionable example, but the VA would make an argument that the presumption of aggravation, not the presumption of soundness, since there was something noted at the time of entry. Okay. Now, that's with regard to his knee. As for his back, there's certainly an argument that the presumption of soundness still applies, because there was nothing noted. He had no pre-existing back condition. Okay. So both the presumption of soundness and the presumption of aggravation can be rebutted by clear and unmistakable evidence. Okay, and here's a little case law for you. What is clear and unmistakable evidence? Evidence that is not merely cogent and compelling, in other words, makes a sufficient showing, but evidence that is clear and unmistakable, in other words, it's undebatable. And the question is not whether the Secretary has sustained the burden of producing evidence, but whether the evidence as a whole clearly and unmistakably demonstrates that the injury or disease existed prior to service. Okay, so just to kind of compare the presumption of soundness and presumption of aggravation, where there's no pre-existing condition noted upon entry into service, the veteran is presumed to have been sound upon entry. The burden then shifts to the government. So if the veteran shows, here's my current condition, here it is, I have it on my discharge medical examination, and my induction physical shows that I have nothing noted, no prior conditions. The burden then shifts to the VA. The government then has to rebut the presumption of soundness by clear and unmistakable evidence that the veteran's disability was both pre-existing and not aggravated by service. The government may show a lack of aggravation by establishing that there was no increase in disability during service, or that any increase in disability was due to the natural progress of the condition. Often with presumption of soundness cases, even if the VA can show one of those elements, it's very difficult for them to show both by clear and unmistakable evidence. There might be a showing, there might be if you were to weigh the evidence, it might tend to suggest that there was a pre-existing condition, for example. But pretty much absent documentation in a medical form that there was a condition, it's going to be very difficult to overcome the presumption of soundness. The reason I'm talking about this today is because this is an area where I often see mistakes on the part of the VA. They fail to apply the presumption of soundness correctly. They may suggest that the condition pre-existed or predated service. Often with psychiatric conditions, the VA will say, well, due to the manifestation, it predated service, pre-existed service. Or because the veteran was sexually abused as a child, it pre-existed service. That is not what the law says. If there's nothing noted on the induction papers, they have to prove that it pre-existed. So if they come up with medical records, school records documenting psychiatric issues for the same condition, then they may have succeeded in rebutting it. But they also have to show that it wasn't aggravated by service. So in the case, let's say, of somebody with a mental condition where they were psychiatrically deemed fit for duty, okay? And the VA has now overcome this pre-existence prong. But they were fit for duty, served for 4 years, and then got medically discharged for a psychotic break. You may have a pretty sound argument that it was aggravated by service, okay? And then the issue is going to be whether it was due to the natural progress of the condition or due to something that exacerbated or hastened or aggravated the condition, okay? Yeah?
Is that part also subject to the CUE requirement, like that level of, to rebut the idea that maybe this was not due to the natural progress, it was hastened? Does the VA have to come back with clear and unmistakable evidence?
Yeah, it's clear and unmistakable evidence to both pre-existing and not aggravated.
On that same point,
Yes.
you can't use a cop and pen as the evidence to rebut that by the government. They can't say, oh, in the cop and pen, they opined that this wasn't pre-existing, or that there was no aggravation during service.
Yeah, that's not clear and unmistakable evidence. It's a doctor's opinion.
Right.
It's not evidence that predates service that says absolutely. This is the key. It's undebatable. So if you think that you have a reasonable argument that, well, I don't know, that I think that might be suggestive, but it's not undebatable, then they haven't overcome the presumption of soundness. Okay, and I'm telling you, we see this all the time where the VA gets it wrong. So something to look for. Okay.
Questions about aggravation.
Sure.
In order for aggravation, like the presumption to attach, does there have to be something noted on the entry physical, or is it just established? You could establish that they had the condition and it was aggravated by evidence predating the entry physical.
So are you talking about, let me be clear, and I don't think I was clear. We use the word aggravation, but there are two times where the word aggravation comes into play. The first is that there's an aggravation prong to the presumption of soundness. That in order for the VA to overcome the presumption of soundness, they have to prove this second element, that it was not aggravated by service. So that's one thing. That is separate from the presumption of aggravation that I also talked about. And if you look through the slides, I put the legal reference just in case you want to look those up. But the presumption of aggravation would be triggered where something is noted upon entry into service. So does your question have to do with that case? Okay. So ask me the question again.
So when something is noted at the beginning of service, then you can use the presumption of aggravation if it gets worse in order to say this, the current disability was made worse by military service instead of the current disability being worsened because of the natural course. But it has to be noted at the entry.
Yeah, so where it's noted at entry, presumption of aggravation is going to apply in the case. So then you're not trying to get service connection for the condition, you're actually trying to get connection for the aggravation, right? So what we heard about earlier in kind of the recap of the basics is that aggravation is a way to get compensation payments. And essentially when the presumption of aggravation applies to a case because something is noted, then that's the benefit that you're trying to get. You're trying to get the amount that the disability has increased. If somebody comes in and they've got a 10%, essentially, under the Code of Federal Regulations, it outlines in the schedule, the disability schedule of ratings, what somebody's disability would be based on their symptomatology. You have to be able to show that it's worse, okay, and that it's not part of the natural progression of the disease. And I'll get into a little bit more specifics on the next slide of that. But what you do, I forgot what I was saying. Okay, I'll probably remember what I was saying when we get to the next slide. Are there any more questions on the presumption of soundness? Yes.
So I'm a little confused. If the government has clear and unmistakable evidence that there was a pre-existing condition even though it was not noted, you don't then get to switch. The not aggravated by service is a different standard than the presumption of aggravation. So you don't get to switch into the mode where you're like, okay, you guys showed that it was pre-existing, now I get to rely on this other presumption.
Yeah, no, I don't do anything if they show that it was pre-existing until they show that it was also not aggravated. They have to do both, and they usually don't do either. And one of the questions was, what if they just have a doctor who says, they very frequently will have their C&P examiner say that it pre-existed, and they do it all the time, and that's why I'm saying this is something to look out for, because that is not clear and unmistakable evidence. Where it gets harder is if the examiner says, based on these psychiatric principles and this literature, then they're getting closer to it. But let's say they do meet the requirement of clear and unmistakable evidence to rebut that prong, they still have to rebut the second prong, that it was not aggravated by service. Okay? So even though it doesn't shift it over now to the presumption of aggravation, because really the question about whether presumption of soundness or presumption of aggravation applies is whether something's noted at induction. That's it. That's it. If something's noted, it's presumption of aggravation. If something's not noted, it's presumption of soundness. Okay? So let's talk a little bit more about the not aggravated then. Oh, I know what I was saying. Is if somebody has a baseline of 10%, you have to be able to show that it's actually increased to a higher level. That becomes a little bit challenging at times if it's something like maybe it's an orthopedic condition and they never did range of motion testing, and for a lot of orthopedic conditions, the schedule of ratings or the VA disability codes are linked to range of motion. So it becomes harder to show an increase in disability, but that is what you have to do. Okay, the presumption of aggravation, by contrast, where a pre-existing condition is noted upon entry into service, the burden's on the veteran to establish aggravation. Okay, so the veteran has to establish the baseline of where the disability was and now where the disability is. Okay? The veteran also has to establish that something happened to aggravate it. It's not just an assumption that the veteran gets. If the veteran is able to do that, then the burden shifts to the government to show a lack of aggravation by establishing that the increase in disability is due to the natural progress of the disease. If the condition has been aggravated and the VA cannot establish it's due to the natural progress of the disease, they don't overcome the presumption here. Okay? Then the presumption applies. The veteran's condition is presumed aggravated. In terms of what the veteran gets compensated for when the presumption of aggravation applies, it's the difference between the baseline of the disability and now where they are. Okay? So if, let's say, they came in at 10% and now their disability meets the 40% criteria, they get the difference of 30%. Okay? Okay. Are there any questions before we move on to the example? Yes?
How much evidence does the veteran have to put forth to meet the initial burden?
For the presumption of aggravation or for the presumption of soundness?
For the presumption of aggravation.
Okay. So for the presumption of aggravation, it's going to be more than the presumption of soundness.
Right.
For the presumption of aggravation, the veteran has to show that the disability was aggravated in service. It's going to be more similar to how you would prove service connection with an in-service event. It's going to be that level of what the veteran needs to do to prove the case. Whereas with the presumption of soundness, the burden shifts quite quickly to the government to disprove. So you always, when we talk about aggravation, you want to be under the presumption of soundness. It's definitely more veteran friendly. And therefore, even if there is something noted at entry, and there is some case law where a veteran had an issue with his knee or with his leg, it was a different leg condition, the attorney successfully advocated, it was Ken Carpenter, by the way, successfully advocated that it was a different condition. And therefore, that specific condition wasn't noted upon entry, so it was a presumption of soundness, not the presumption of aggravation. Okay. Any other questions? So, clear and unmistakable evidence. The veteran injures his knee during a training exercise in service. Over the next few years, his knee buckles a number of times and he sustains several falls. He injures his back on a fall. Nothing is noted upon induction. Pre-service medical records document that the veteran injured his back in a car accident prior to service. In a statement in support, the veteran states that he may have also hurt his knee at that time, but doesn't remember. Okay, so what thoughts? What applies, what doesn't apply? What is or isn't rebutted?
So presumption of soundness on the knee and aggravation of the back.
Okay. Anyone else? Any different thoughts? Yeah.
Start with presumption of soundness on both, but they would have an argument that there was an aggravation of both. That it was pre-existing, and there would be an argument of possible aggravation.
That what was pre-existing?
I would say they have an argument that both, but they don't have clear and convincing evidence of the knee.
Okay, clear and unmistakable.
Clear and unmistakable, sorry.
And I'm glad that you said clear and convincing, because there's a distinction. Clear and unmistakable error is clear and unmistakable evidence is a higher burden than clear and convincing. I have to be more than convinced. I have to have no arguments. You have to strip me of all of my legal arguments. Okay, other thoughts on what may or may not apply? Okay, I'll put this out there. I'm not entirely convinced by either of the two suggestions. Yep.
I think they haven't overcome the presumption of soundness.
Okay.
First of all, nothing is noted on his induction papers.
Okay.
Second of all, they may be able to use that medical record about the car accident to rebut one prong, although I'm not convinced that's enough
Okay.
to rebut one prong, but they still haven't rebutted the prong that maybe it was aggravated in service, and furthermore, this seems it could be a completely unrelated back injury, right? Because he fell on it. He didn't crash a car again. So maybe it's a different part of his back. You know, you can make that argument. And then I still think there's just no way that you can rebut with any amount of evidence other than the veteran's own words that his knee was hurt in that car accident.
Yeah, and here, let me, and I put this in here because it's like, I didn't even address it, but I think it's important to say. The veteran's own statement is not enough to overcome clear and unmistakable evidence standard. His statement, first of all, that he doesn't really, maybe, but doesn't remember, definitely not strong enough. Secondly, there's case law that indicates that the veteran's own statements may or may not be reliable as to what injuries they may or may not have had prior to service. So it's not a medical record. The veteran's statement thing comes into play even more if it's a psychiatric condition. And it's important because the VA will often try to use that as rebuttal of the standard. But that's why we're doing this presentation. We want you to know what to look out for. So I would agree with the assessment that the presumption of soundness applies to both, and that it may be rebutted as to the pre-existence, but they haven't addressed aggravation. So I don't know if it's rebutted by clear and unmistakable evidence on the aggravation prong, and that the may have hurt his knee. I addressed that. So as to the knee, there's nothing that would overcome the presumption of soundness. Yeah.
How could they possibly submit evidence that's undebatable, but it was not aggravated?
They have a clear doctor statement based on medical, based on treatises and their experience that.
But in practice, they probably just say he never came in and complained about his back while he was in service.
Yeah. And they might win on that. That might be clear evidence that it wasn't aggravated. It wasn't to the point where it was bothering him or he was going in, getting Motrin from the medic. But what I would recommend doing in that case is a statement from the veteran, from buddies, from family members who know that it was getting progressively worse or that something happened. Because usually what happens is something else happens in service, or even just, carrying 50 to 80 pounds on a regular basis on your back is going to aggravate what may have predated service. Any other questions on this? Okay. Now, I use the word presumption because there are a lot of presumptions, because there are different types, they mean different things, okay? But now what I'm doing is I'm going to talk to you about clear and unmistakable error, which is somewhat different from clear and unmistakable evidence. Clear and unmistakable evidence is what the VA needs to do to rebut the presumption of soundness or the presumption of aggravation. Clear and unmistakable error, and we sometimes see cases like this. This is a kind of error of factor law that, when called to the attention of later reviewers, compels a conclusion to which reasonable minds cannot differ, that the result would have been manifestly different but for the error. In addition, generally either the correct facts as they were known at the time were not before the board, or the statutory and regulatory provisions extant at the time were incorrectly applied. Okay. We talked a little bit earlier about there are timelines that apply in these cases, statutes of limitation. Okay, a veteran gets a rating decision. There is how long to appeal that? An initial rating decision? 1 year. 1 year to appeal the decision. Okay, and the veteran may select the decision review officer process, or may select a traditional route, which will essentially trigger a statement of the case to be issued. After a statement of the case is issued, the veteran has 60 days or 1 year from the period triggered by the initial rating decision. The VA takes so long to make these decisions that typically you don't see that, but it does apply. It does come up every now and then. So usually it's 60 days, but keep an eye out if there's a rating decision and a statement of the case that are issued relatively close in proximity, then it's not 60 days. The veteran or the claimant actually has 1 year from the underlying rating decision. And it may make the difference between a veteran being able to appeal a case or not. So something to be aware of. But let's say a veteran comes to you, or you're getting a case where the veteran is now outside of the time limit to file an appeal. But there was clear and unmistakable error in the decision. That would be the only way to request revision of a decision. Okay, the veteran can file a claim to reopen based on new and material evidence. But let's say the veteran doesn't have any new and material evidence because all the evidence in the file at the time was really everything the veteran had, and it clearly and unmistakably showed that the veteran should have been getting service connection. Okay, then that's when you would file one of these. Yeah.
I have been super confused. So this says we're not before the board. Does this only apply to decisions at BVA?
No, I'm going to get to that. It applies to both, but there are different standards for whether the decision is a BVA decision or whether it's a regional office decision. So I will get to that. Okay, so clear and unmistakable error allows a final decision to be revisited. The decision must be final. So what does that mean? It cannot have been a provisional decision. I don't know if any of you have heard of these or seen them. For a period of time, the VA, in efforts to reduce the backlog and or contribute to it more greatly, issued provisional rating decisions, which basically said, we're not actually making a decision on this and we're not actually giving you appeal rights, but here's what we're thinking of doing. So if you want us to make a decision, send us more correspondence. We're gonna sit on for a year and a half before we do anything with it, telling us that you want us to finalize this decision or submit evidence. So it basically bought them more time, and they could take things out of their new claim status and put them into some other category. So when they were talking about the claims backlog, they got to say, we're reducing the claims backlog. Okay. By the way, when they say claims backlog, they're not talking about appeals. That's something to be aware of. And the appeals backlog, it's a huge abyss. It's a huge black hole. Nobody's talking about it. People are languishing while these appeals are just sitting there for 3 to 5 years on average. So, sorry. I get a little worked up when we talk about these procedures. So if they issued one of those provisional decisions, that is not a final decision. Okay? Additionally, if you're still within the appeal period, it's not a final decision. The remedy, if you're still within the appeal period, is to file an appeal. Okay? And you want to do that because the evidentiary standard is at least as likely as not. It's not undebatable. Okay? But this is sort of a final straw. We've got no other options kind of deal. Or the error was just so clear and unmistakable that even the VA, this is really the level, even the VA would have to admit, oops, we were totally wrong. Okay? This is not, well, maybe. We see your point. This is not that. This is, yep, absolutely, we were wrong. The effect of the revision is that the correction to the decision is deemed to have been made on the date of that prior decision, thereby allowing retroactive benefits. So let's say you're able to successfully plead that there was clear and unmistakable error in a decision that's 30 years old. The veteran will get the benefits back to that date. Okay? Clear and unmistakable error. So we refer to them as Q claims, although they're technically not claims. They are requests for revision. But you may hear Q claim. You may have people asking you if you can file Q or there's Q. And I was talking to Margaret about this earlier. The VA often makes mistakes, but it's very rare that the mistakes rise to the level of clear and unmistakable error. So something to be aware of. Always look out for it, but it's very difficult standard to prove. And it is, I think it's in case law that it says this is a rare kind of error. Okay, so present either when the correct facts or evidence known at the time of the decision were not before the regional office or the BVA. What does that mean? I see it fairly frequently where the VA denies a claim to a combat veteran who's claiming for PTSD and a back condition incurred in service, saying there's no evidence that you served in combat, you don't have a combat infantryman badge, there's no evidence that you earned a Purple Heart. And let's say there is evidence that the veteran had a combat infantryman badge or had been awarded a Purple Heart, that would be clear and unmistakable evidence, okay? And it would potentially be clear and unmistakable error depending on the other facts of the case. For example, if the veteran in that case has a current diagnosed condition of PTSD based on combat service and has a diagnosis of a back condition, at least as likely as not related to service, okay, so the other elements of service connection are met, then there may be clear and unmistakable error that can be revised. Okay? The other thing in this I see probably more frequently is that the law at the time of the decision was incorrectly applied. The thing about the first element is that it usually falls into the category of how they weighed the facts and how they weighed the evidence as opposed to whether they had them or not. Clear and unmistakable error, I always think of like an accounting error where you see they've inverted numbers. I had a case where the veteran had hypertension. It was clearly noted. His numbers clearly under the schedule of disabilities were hypertension. He had the number of readings he needed to have. And they said there's no evidence of hypertension, and they inverted the numbers of his readings. That's clear and unmistakable error. And even they would look at it and say, yeah, oops, we messed up on the numbers. But usually the facts, if it's with few exceptions like the ones that examples I gave, it's probably not going to fall into that category. More often, though, you can find that they misapplied the law. Presumption of soundness could absolutely fall into this. So I had a case where, and we'll talk a little bit more about it, I think, in the example, they medically discharged the veteran. Nothing noted at induction. He was medically discharged for a mental condition of neurotic proportions. And they said that it predated his service. That's it. They just said it predated his service, nothing else. There's no evidence, no medical records, nothing prior to his service. So we'll talk about that in the example. So that's a good example of how they failed to apply the presumption of soundness. Had they applied the presumption of soundness when he applied 2 weeks after he was discharged, he should have been granted service connection. Okay?
Are there waiver problems or preservation issues if you hadn't made that argument at the time? That is, if you didn't argue for the application of the
Nope.
presumption? Okay.
Nope. A lot of the veterans, and probably a lot of the cases you're seeing, are people who are not represented. And they're not expected to know what the law is that applies to them. The VA is. So that's why they're allowed to revisit it. Yeah.
Did you say a few minutes ago that no CID means no PTSD? The VA takes that position, really?
Oh, absolutely. That is, and let me tell you, they absolutely will take that position.
What's a CIB?
Combat infantryman badge.
I know that.
It is an absolutely incorrect position to take. It is not based in law. In fact, it's contrary to the law. So it's certainly something to look out for. Anytime I see that, even if there's not a current diagnosis, I take it as a red flag because there's probably some diagnosis coming out of it. And if they're misapplying the law in an easy way like that, then that's sort of a gimme. I'm sure there's other stuff in there. Okay. So I think we went over that. Okay. The other thing is you have to show that the result would have been manifestly different. Okay, this means the outcome would have been different. So I don't win it if there's clear and unmistakable error, but it's only on one prong and I haven't proven the other two. I don't get it. We don't get to reopen it. So something to be aware of. And this can actually sometimes be the hardest thing to show, that it would have been manifestly different. How to plead Q is going to depend on the type of decision. If it's a regional office decision, the motion for revision goes to the secretary. In other words, it's going to go to the regional office. These days, everything's going to the evidence intake centers. If it's a BVA decision, it's got to go to the board. Okay?
And there's no time for that. Like, it's a regional office decision from a billion years ago. You file it at regional.
Yeah. And I'd love to see one from a billion years ago. I'd be really curious. But yeah. You file at the regional office. Absolutely. Warning, I have this in here a bunch of times. There's pretty clear case law now that has not too long ago come out, this Hilliard case in 2012. If it's a BVA decision, you get one shot to plead it correctly. So you better make sure when you're pleading Q that you've got all the facts, you have all the decisions, you know all the procedural history, you have a good sense of what was in the file at the time. Okay? This is not necessarily the case if it's a regional office decision. Now, the attorney who argued this case argued that that it should be treated like it is treated at the regional office level, where if Q was pled on one basis in the past, but now we see that there is a different basis to plead Q, we can plead it. Case law says if it's a regional office decision, have at it. You can't plead the same legal argument, but if it's clear and unmistakable error, and there are two types of clear and unmistakable error, and either one of them would be sufficient to meet the standard, you can argue that second one. Not the case if it's a BVA decision. Okay? Here's what's critical. To obtain the underlying decision, research the applicable law at the time, get the claims file, review the procedural history. It can be difficult to know what was in the file at the time, and so that's a big challenge. That's why the clear and unmistakable error based on facts before the board or before the regional office is going to be a harder clear and unmistakable error claim to win than application of the legal standard. And for that, you got to do, you got to pull the old statutes. So what I recommend is don't assume that the VA has access to the code from 1968. Go pull it yourself. Submit it as an attachment. Here's why the application is wrong. The other thing is these claims have to be pled with specificity. You need to be pretty clear on why it's clear and unmistakable error if you want to have a shot of prevailing. The other thing is this. You may want to consider whether to first file a claim to reopen. If the veteran was denied benefits, okay, and now there's a new medical opinion, or there's the issue was diagnosis, and now there's a change in diagnosis, you may want to first file that claim to reopen based on new and material evidence and get the grant of service connection. Any thoughts on why that may be? Yeah.
By doing that, then you can prove that they do feel there's one, so when you go back on your queue, well, obviously if you knew what you did then.
Exactly. It helps with the manifestly different argument. I had a case where the VA failed to appropriately apply the code pertaining to service connection of PTSD based on military sexual trauma, and specifically what evidence it will accept. With military sexual trauma, just like with presumptive conditions, when you fall into these categories of PTSD like MST does, you sort of get these hybrid requirements. So instead of it being in-service event, current diagnosed condition, and a link, what you can have if you don't have evidence of that in-service sexual trauma, if you have a VA examiner who says, this person was sexually assaulted in service, here's the basis for my opinion, that sexual trauma is the basis of my diagnosis of PTSD, that's sufficient to corroborate the in-service stressor. I have a case where the VA failed to apply that, and there is a C&P examination, and the examiner details why this veteran was raped in service. In 2014, we were able to get her service connection on the basis of that earlier C&P examination. So now that she's got service connection, you go and file the motion for revision based on clear and unmistakable error. Okay. The veteran serves in the U.S. Army. During his service, he's misdiagnosed with ADHD. He's medically discharged for a mental condition of neurotic proportions. A medical board states that his condition existed prior to enlistment. He has no pre-service diagnosis. He files a claim for service connection 2 weeks after being discharged in 2006. During the pendency of his claim, he's diagnosed with bipolar disorder. The VA denies the claim. In 2009, the veteran files a claim to reopen with a letter from his doctor stating his bipolar disorder is at least as likely as not related to service. Okay, so what are the issues here? Was there clear and unmistakable error? And if so, what should you do? Let me rephrase that. Do I think there's clear and unmistakable error here? Yes. Why do I think there's clear and unmistakable error here? And then do you disagree with me? Yeah.
Would the presumption of soundness apply in this case? Or?
Absolutely, the presumption of soundness applies. Is it rebutted?
Sufficiently? I don't think so.
I mean, is it even... Yeah, I mean, it's... So is it rebutted? That's... The next question is, well, in order to determine if it's rebutted, we have to determine whether there's clear and unmistakable evidence to rebut the presumption of soundness. I don't think there is. I don't think there is. He files his claim within 2 weeks after being discharged, medically discharged. 2 weeks after being medically discharged. Okay? What about that? What about presumptions of chronic conditions? Anyone know about that? Psychosis is a chronic condition.
Keep going. You have it then and you have it now. You probably have had it.
And to be clear, there's been documentation through the years. He's filed his claim many times for the same condition. So I'll tell you what I think. I think the key is you first get him service connected. Okay, so he's filed the claim to reopen from the doctor stating it's at least as likely as not related to service. He meets all the elements, okay? And what I would recommend doing is at this juncture saying, hey, if you apply the presumption of soundness, which applies in this case, it was never sufficiently rebutted. A statement from a doctor at the time that he's being discharged that it pre-existed service without clear and unmistakable evidence documenting that does not rebut the presumption. Okay? And then once he gets service connection, then I think you try to revise that earlier decision. Where the pitfall, where you got to be careful is that the VA will likely say, well, the reason we granted him service connection is because he has a statement that his current diagnosed condition, which is bipolar disorder, which is a different condition, is at least as likely as not related to service, and so it's different. But the bottom line is he filed within 2 weeks. He had a diagnosis at the time of discharge. I will tell you what the VA tried to do in this case is they tried to say, he didn't have a diagnosis at the time of discharge. So even though we concede that we failed to apply the presumption of soundness correctly, there's no current diagnosed condition. But we have a medical board finding that diagnoses a condition. So... Anyway.
So I feel like I'm missing something here.
Yes, you might be.
It says a medical
I might have
board,
not put it in there.
No, I'm sure it's a medical board states that this condition existed prior to enlistment. How do we know that?
You would have the file, because remember, before you're going to file a claim, a revision.
So I can presume that there is something in his file that says before he was enlisted, he'd already been diagnosed with
No.
ADHD.
You're going to find in his file is a medical board finding that says this veteran is not fit for duty because he has a mental condition of neurotic proportions, and it pre-existed service.
And they know that because...
That's it. That's all that it says.
That's what I was saying.
And they know that because is a good question because the answer to that question might tell you whether there's evidence to rebut that prong. Okay?
But you can usually get you can get some of the board's thinking, right, when you request the records, that's sometimes in there.
The medical board finding should be associated with the veteran's claims file. If it's not, that's problematic, and you may have an issue with the fact that that first prong of clear and unmistakable error of what was considered at the time. But if it's not in the claims file, you can request it from the National Personnel Record Center. It should certainly be with his personnel file. Yeah.
I'm a little confused. So he was diagnosed with ADHD. He gets med worked out based on the ADHD. But the claim he files in 2006 is for ADHD.
The claim he files.
Yeah, in 2006. Right.
Yes. But there's also case law, and this presupposes a certain level of knowledge that I haven't gotten into.
They should have read that as
Any mental condition. Any mental condition under Clemens v. Shinseki, not me. Any mental condition, it's all packaged in the same way. Whether I file a claim for bipolar, but I have a diagnosis for PTSD or depression or ADHD or whatever it is, whatever that misdiagnosis was in service, which that's why I put that little nugget in there. There was a misdiagnosis in service. They diagnosed him with ADHD. They treated him for ADHD. They gave him medications that sent him totally off the deep end, because when you treat somebody who has ADHD, or who has bipolar disorder with medications for ADHD, and that's all you're giving them, you're going to have some problems. So he was misdiagnosed in service, and he did. What I didn't include here, he did have a diagnosis from a doctor that was submitted with his application for benefits that diagnosed him at the time with bipolar disorder. This case also, what I didn't say here is it's a 1991 case. I said 2006, it's a 1991 case. So his Q claim actually goes back to 1991. The reason I didn't do that is because I wanted you to assume that the law said the same thing that it says now, and basically it does. The version was a little bit different, but the presumption of soundness is pretty much the same. Yeah?
You said that once we get this filed, we're going to see just a statement from the medical board with the diagnosis.
It should be in the claims file. Okay. It should be in the claims file, yeah.
The statement should be based on something. I mean, they should give a long time for that to be tested.
The statement could be based on the fact that he has a mental condition of neurotic proportions, and they don't want him serving in the Navy or in the Army.
What I'm getting at is, don't we see the underlying basis for...
They don't have to give an underlying basis. There doesn't have to be one. There could be one. There could be medical records from his childhood. There could be, but there aren't.
So how do we fight that?
If they just say it's this and they don't say what it's based on, I would argue it. If they don't reference any medical documentation showing that it clearly and unmistakably pre-existed service, how do we know that it pre-existed service? Even if they say based on sound medical principles, how do I know what those principles are? I don't think that's clear and unmistakable. I don't think it's undebatable. It has to be undebatable. If they had no records to base their opinion off of, which in this case they had no records to base their opinion off of, that's problematic. For them. And hopefully it's going to be good for our veteran. Yeah. I mean, so now I think you can see how worked up I get about this stuff. So if you have any questions, call me or email me. But also just think about like the little me on your shoulder when you're going through these files. And if you're thinking, would she argue it, then you it might not be undebatable.
I'll do that for you too. I want to get real fired up.
So that's all I have. I'll be around later for questions. Here's my contact information. It's my direct office number.
Starting my piece. Okay, so we're going to do a little case example to sort of get our problem-solving juices going, so we feel practice ready. You should have in front of you this redacted typewriter thing. Okay, so what I want you to do is quickly read through this, and we're going to talk about what's interesting about it and what we might do if we had a client bring us this document. Okay? So I'd recommend reading it, and then also maybe like talk to the person next to you for a couple minutes about what you think the next step is. Okay. My redaction was less than perfect. All right, I see a little talking. That's great. Feel free to share with people next to you.
So this shows the connection
We really just want to know. Okay, so in the interest of time, I'm totally cutting out our ability to talk to each other. Sorry. Just going to talk directly to me. The first thing you might notice is that I failed to properly redact this document. Fortunately, this client's been very. The story of this client is in our annual report. It's represented by Mr. Brady's firm. So this is not a secret. This document in particular was not a matter of public record. So what's interesting about this? Like anything at all that's interesting about it? Not not looking. I'm not playing a game with you. I don't have any specific answer I'm looking for. Anything at all that stood out to you? Please.
I did not know at least why he was discharged, what his discharge status was.
Okay, we don't know what his discharge status is. We know he saw a shrink while he was in.
Correct.
So something wasn't cool.
Right.
Even then.
Right.
Yeah.
What I was wondering was whether there was a diagnosis during the time that he saw the professional during the service. Didn't he see a psychiatric professional?
Right. He says he saw one.
Was there a diagnosis? Was there something?
Right.
A condition?
Right. I mean, is there even a record that this meeting happened? Anybody else? He what?
He's got a service.
You think he meets the criteria for being service connected? Yeah. I would agree with you. He has established that he had problems while he was in the military. He has a medical opinion that reflects that opines on the connection between what was happening in the military and the level of his current disability. What's that? It's a condition of a chronic nature. I agree. So when this veteran came to me and I went to read his claims file and I saw this, I was like, whoa, what are we possibly going to do differently that this veteran hasn't already done? It's really service connected. Anybody else was weird about this?
No, I didn't have any information about his employment history before entering the military. That comparison would have been interesting.
Okay. So, and I would just note that there was evidence of his employment history, right? So the medical opinion wasn't just based on his self-report. It was also based on documented history of not being able to maintain employment in the time following the service. Anybody else? What's interesting about this? Please.
He was denied the opportunity to read this based on a medical condition which they can specify.
Right.
So he obviously had it while he was in the service.
And I can tell you just outside of the record that we could never find any documentation of this. So he says that it happened, and they're like, well, how do we know? So what I want to talk about, I want to use this case to flesh out is a few ideas. One is what options are for previously decided cases. We've talked about that a lot today, so I won't go into it too much. I want to talk a little bit more about specific presumptions, including psychotic spectrum disorders. And then the thing I mostly want to talk about is working with medical experts. How many folks here work with medical experts in their day-to-day existence? I guess, okay, so many of us. So it'll be really interesting to hear from you if this is similar or not. How many of you, though, do that on the plaintiff's side? Okay, my plaintiff's attorneys. It's going to be a little different from those of you who don't. So, having read this, what would you tell this person? Let's just say, hypothetically, that this was dated about 1986. This person comes to you, they bring you this. What are their options? You've already done this as a trivia question, so you know the answer. Anybody? Looking at you. You made eye contact with me, Schaefer. Come on, this was literally a trivia question. Well, okay. I guess I'll give you some ideas of what I came up with. One was that the reasoning was poor. I agreed with Ted. I was like, this doesn't cut it. This person had multiple witnesses. The opinion totally discounts the expert, and there's corroborating hard evidence about his employment history. Okay, so what could happen on appeal if this had been timely? So if we hadn't gotten this 30 years later, the next step is that we would have appealed this to the VBA. 30 years later, maybe, as Christine just explained to us, we could file a Q motion, or in fact what we did in this case was we filed a new application and submitted new and material evidence to reopen the claim. I want to mention that because a lot of you will probably get cases where people have applied before and been denied. It's very, 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 very common. I would love to know in the claims backlog what percentage of those cases have already been adjudicated once or multiple times. A lot of what happens is that veterans file a claim, they lose, they still feel like I should be service connected for this, and so they reapply without really submitting anything materially different than what they submitted the first time because they lack you. With your help, they're going to submit something that actually is going to fill in the missing gaps, and that's what we did in this case.
Hey, Margaret, is there a reason that you didn't do both? Also do a Q motion?
Such a good question, and the answer is we just didn't really know that much about it, and I think that we should do it now. And I'm pointing at Fran because I hope that maybe his firm would do that. I think that we should do that now, yeah. But I would also add that I think that this, based on this letter, I think it sort of fits into Christine's territory of this was a question of whether they weighed the evidence correctly, not whether they disregarded a smoking gun. This doesn't rise, to my mind, to the level of accounting error. So it's a winnable thing, I would think, but it's not a sort of like a slam dunk. Would you agree with that?
Yeah, I mean, my question would sort of be what the other medical evidence in the file says, right? Because it's most likely a weigh. This, to me, sounds like it's a weighing of the evidence.
In which case maybe
it's not like saying somebody didn't have a diagnosis when they had a diagnosis.
Right. So the problem is that the stuff that he's talking about, not the attempt to re-enlist, there's no actual documentation of his psychiatric visit while he's in the medical service. I have no doubt that those things happen, but we don't have any paper record of them happening. So we may still do that, but we could have done them both at the same time, I think, is the answer.
Yeah, you can do the Q at any time. You can do it before you get the service connection, but it's easier to argue the Q successfully if you already can show that the result would be manifestly different because it is.
And I will say that what we ended up submitting essentially wasn't any different than what was already submitted. We submitted another expert report that was based on the same underlying factual basis. It was just a more compelling expert. Okay, so part of the reason I wanted to talk about this case was that this veteran has a psychotic spectrum disorder, which is on the list of things that are presumptive conditions. And to me, this is my single favorite class of cases because, and something that I think you guys are, at least a few of you are likely to see. The reason that I love them is they're kind of hard in an interesting way because unless you have a psychotic break, like you are floridly psychotic while you're in the military, there's no record in your military treatment records that says this person has schizophrenia or this person has psychoaffective disorder. And that's really what the VA is looking for. If they see that in the record, that's easy peasy for them. They're service connected. What you're more likely to see is someone who doesn't show up for muster, someone who's not taking enough showers, someone who goes AWOL for weird reasons, things that are often sort of look just like a bad behavior, and then 5 years later when the person has a full psychotic break, they look like prodromal schizophrenia. And so I think these are really neat cases to work on. The rule is that the person has to be 10% disabled within 1 year of their discharge from the military. What is 10% disabled? You look it up in the rating schedule, you'll see what the description is. It's not that much, actually. Any of us, I would say, is probably 10% disabled right now. So it's not an impossible standard to meet. Similarly, I'd encourage you to be familiar with the Agent Orange-related presumptions. So any veteran who's set foot in Vietnam and has diabetes, Parkinson's disease, ischemic heart disease, or prostate cancer, and I picked these 4 out of a much longer list because these are so common in the general population, is going to be presumptively connected. So your file may say this person wants to get connected for PTSD, but if you're smart when you're looking through their medical record, you're also looking for this stuff. Similarly, there's PTSD. There's a presumption for PTSD when it's either diagnosed in service or it's based on a fear of enemy contact and consistent with military service. You're not super likely to see these because these are so easy that we just file them. We're not going to give them to you. Okay, I wanted to talk quickly about working with experts. So this might be this is a different kind of working with experts than you guys do, right? Because for one thing, this is purely administrative. There's no discovery here. So email to your heart's content with your expert. No one is going to be filing a motion trying to look at what you had to say. The other thing is that our clients are poor and they can't afford an expert. So a lot of what we do, yeah, you're nodding, is we beg people to do these evaluations for us. We have Madeline Baranowski from the Yale School of Medicine coming to talk about their work in the forensic psychiatry program, doing these evaluations, which they do a number of for free for us, which we're very grateful for. She was in a car accident on her way to this training, so we hope she gets here. So I wanted to share with you first a little bit of what not to do. This is an email that I sent to a clinician when I was working on this claim. So this clinician is a VA employee. They are under zero obligation to assist this client at all. We're not paying them. We're just asking them to sort of do this documentation out of the goodness of their heart. I would call your attention to, so I'm asking her to write that the being on a submarine was likely to have triggered the depression rather than possibly triggered it. I wanted to just make sure that we were reaching that as likely as not standard. And I even go so far as to say, I entirely respect your professional opinion and your professional boundaries and only plead with you for this word change because I believe it is likely that his experience triggered the depression and his claim for benefits really hinges on the difference. So I'm like, this is probably the nicest email I've ever sent, as my staff will tell you. This was her response. Dear Margaret, it is good the way it is. Please do not request further modifications from me about this topic. So the lesson learned here is that I needed to be very clear when I spoke to her the first time about what the standard was and what language I needed. And Madeline can talk more about the way that doctors just see the process of diagnosis entirely differently than the legal system asks them to. So that's what not to do. What to do, so it's extremely, extremely likely that in whatever case you have, you're going to want a medical opinion. It's extremely, extremely likely. The best thing is if your treating VA doc will do it for your client. That is the best possible thing. That means the person who sees them all the time and is already treating them does a form. It's called a disability benefits questionnaire. If your VA doc will do this, you're like in magical shape. You don't have to pay for it. The person already knows the veteran. And they aren't sure whether they can do this or not. The VA doesn't give them a lot of guidance. So this is territory you want to tread into with them lightly because you will scare their pants off just by calling them, essentially. Here are some challenges that you might foresee and try to prevent when talking to an expert in this context. One is, like from my previous example, making sure that you communicate the evidentiary standard and why it matters. That kind of word change to her clearly just was like pure nitpicking. It just didn't have any meaning to her. So I hadn't adequately explained why the evidentiary standard mattered. The other thing that can be challenging is convincing an expert to leave out irrelevant but damaging information. To give you an example, Christine mentioned, talked a lot about the presumption of soundness. In military sexual trauma cases, experts often want to include information about how the person was sexually abused as a child. Is that relevant to their processing of the trauma of being raped in the military? For sure. Is it relevant to their medical diagnosis? Totally. Does it matter for them getting service connected? Not even a little bit, because that's not the basis of the claim. However, it does sort of raise the question in the eyes of a VA decision maker as to whether this was a pre-existing condition, and then we have to get into that whole conversation. So convincing experts about what the difference between what's legally relevant and medically relevant can be really important. The other thing that can be challenging is using the language of causation when there are multiple causes. The sexual violence example is a good one. So this person was sexually assaulted as a child and then again in the military. Arguably, there are multiple reasons why this person is experiencing post-traumatic stress. So it may be hard for an expert to say the military sexual trauma, as likely as not caused or aggravated the PTSD, because they're thinking, well, that caused it, and being raped as a kid caused it, and, being assaulted at the high school prom caused it, and it's really just a terminology problem. It's just a different understanding of what causation means. So oftentimes when I'm trying to get a free expert report, which is really what we're talking about, I ask people to just talk to me about the case. I don't say to them, I'm coming to you looking for a free evaluation that's going to take 40 hours. I say, hey, can you help me figure out if the theory that I'm working on here makes sense? Because if the theory does make sense, a lot of times they're not going to have a problem going along with giving you the documentation that you need, starting with the idea of, doing an evaluation freaks them out. The other thing you should know, particularly in the psychiatric realm, is that very few people are trained in forensic psychology and psychiatry, and so they see that as a different field about which they know nothing. They consider themselves clinically treating folks, and so you're asking them to do something that's a little like, I'm a litigator, I'm not really prepared to help you in this transactional matter, or vice versa, just to give you a sort of an analogy. So helping them feel one thing I really like to tell people is, if you don't do this, absolutely no one is going to. So if their VA treater isn't willing to provide the documentation, or somebody isn't going to do this evaluation for free, they aren't going to get it. What they're going to be stuck with is an evaluation by the Department of Veterans Affairs. It's called a compensation and pension evaluation. It takes about 45 minutes. So we're talking about an entire review of your client's history, a 45-minute interview, and that is the medical opinion in the case, which is rarely sufficient. The last thing I would say, and I'm sure you do this with your own experts, is we always offer to draft language for them. Obviously, they modify it as they see fit and make it their own, but it's always a good idea to offer to do the heavy lifting, essentially. Okay. That's my spiel. I already got my 1-minute notice, so I don't have a ton of time, but I would take questions. Anybody curious about this part of this? Please.
I came in late, but I'm with disability law for 20 years. I'm a Social Security attorney in Sonia, and I've never really done a VA case, but when I was working with Social Security, I got some training in VA, and I noticed the question that you posed that, for example, job, and also with the evidence. What I want to find out, in Social Security, the medical experts approach a certain way. In Social Security Administration Act, in the VA Act, what would you say is the difference?
Well, I'm not an expert on Social Security Administration law. I do know that in the SSA context, they send out for an independent medical evaluation, right? So they send it to a doctor that they contract with. In the VA context, they send it to their own doctors. So this person is somebody who treats veterans for a living in addition to doing these evaluations. And there is a perception that VA clinical folks will talk to you about quite readily, a perception that a lot of veterans are trying to game the system, that they are made uncomfortable when their clients ask them to help with these cases because they feel like it interrupts their therapeutic relationship with this other thing that isn't really their business. They're here to help heal somebody, not to help them get money. So I think the institutional mingling of the expert opinion and the treatment relationship is super problematic in VA. I sometimes wish that they would send it out to an IME, although I don't think the Social Security Administration is amazing either.
Oh yes, Social Security is extremely fair in that.
In that way?
Yes.
Oh, well, that's good to hear. Maybe we should do that then.
What they do, they settle that independent CEO or examination, and it's not very objective. Sometimes the client can use their own doctor to do this.
Right, and that's what we love the most, is when we can convince somebody to do a free evaluation. So if you have one of these cases and you're like, we really need an expert opinion, the VA doc absolutely won't do it, let's talk, because we have very few but existing resources to sometimes help get evaluations. We have some law firms that have in their pro bono budget some amount of money to pay evaluators. We can always get you an amazing evaluation in that case for like what is shockingly cheap compared to what you're used to paying an expert. So if you have that in your budget, please let us know. There was another question, I think.
Yeah, Margaret,
please.
Just a practical question. On this offer to draft thing, you ever encounter a situation where this expert is testifying somewhere and somebody says, who drafted this opinion? And the answer is, the lawyer did? Isn't that a problem?
No, because there's no discovery here. So this isn't like the...
What if he's testifying?
I mean, they could be testifying in the context, for example, of a VA administrative hearing, but that's, I mean, first of all, that's just never come up. But second of all, I think that's an answerable question. Like, I don't mind saying that I drafted something. Like, so I drafted it. It's still their opinion, right?
You have the guy admitted before it's a cross-examination question. Is this a document that you reviewed and that you and I prepared?
Right, so Ted's suggestion is that you have them just state off the bat, like I worked with the legal team on preparing this evaluation or something like that. The other thing that's important to know is that the VA, this is supposed to be a non-adversarial system. So there is nobody on the other side doing that kind of cross-examination. Their job is only to weigh the credibility of what's there, and so they rarely take that sort of hard look really at what came across. I also have no problem with the idea that attorneys draft language for doctors. Like, it's our case, we have the time, it's their signature and their medical license. Like, they shouldn't sign something that they don't agree with, and they have, so that's what I would say. Anybody else? Because I do need to wrap up. Oh, good. Please.
I would say I've actually never had a doctor ever testify at a BVA hearing, and I do this quite frequently. When I contact with experts, I tell them it's for a veteran. I try to get a reduced rate, and I've found a number of experts who will do that. And for some experts, knowing that they will never be called on, it's not a court proceeding, they won't be called on to testify in court in front of someone, helps them, to be able to just put it in writing and feel okay about that, and also about charging them a reduced rate.
Right, so that Christine's point is that they don't have to testify in this at all. We do have experts testify in part because we often partner with Madeline's fellows who are doing a fellowship at the psychiatry department. Testifying is part of their training, and so they want to testify, we want them to testify. But that's certainly an option too, is that you submit the medical opinion without, any cross-exam, essentially. Okay. Thank you very much. That was fun for me. Madeline Baranowski is here with us today. Thank you.
Thank you.
She is an associate professor of medicine. I'm going to say in the law and psychiatry program in the School of Medicine at Yale University. She also is the founder, I think, of the New Haven jail diversion program. I know Madeline because she and her colleague Howard Zanana have worked with the Yale Veterans Legal Services Clinic at Yale Law School. Their fellows in that psychiatry forensic psych training program are actually cross-listed with our clinic, and so we have had this really interesting opportunity to work with medical experts in this really close setting. In addition to her unbelievable professional credentials, Madeline was a Army nurse and served in Vietnam
I'm going to say 1971.
Yeah.
I totally looked things up. I think Lorena did that, actually. So without further ado, I'll introduce Madeline and thank her so much because her car has been towed. Her husband drove her here.
Yes.
Total.
Let me drive.
Oh, God.
So I'm late. It's Friday. I better be good. So I think about this as anything you want to ask about experts or about how we think. And I just want to start by saying that what's different about medicine and law is that medicine's never sure about their opinion. And it's partly because of the way science works. Science is truth discovered, right? So whenever you come up with an opinion about a case, it's a diagnostic guess, and then you look for confirming information, and then you change your diagnosis and look for more confirming diagnosis. So when you want reasonable medical certainty, it makes a lot of experts very nervous about how much certainty they need before they can say this is absolutely reasonable medical certainty. That's one. And then unlike your case law that really distinguishes what the precedent is, diagnoses are working hypotheses, right? And they categorize illnesses that are on a spectrum. So there are a few people who land right on PTSD or right on psychosis, but most people have a little bit of this, a little bit of that, and it moves through. So when you review records, you're going to see a whole cascade of diagnoses. And most of them are going to start with adjustment disorder. And one reason they start with adjustment disorder is it's a disorder that allows a little bit of a not completely emerged disorder that lasts for just a short time. And then if the person keeps coming back, you see adjustment disorder begin to morph into other things. You also see that schizoaffective, schizophrenia, no, it's schizoaffective, no, it's bipolar with psychotic features. And all that's being said there is there's a psychotic illness and an affect, emotional discontrol. And depending on the moment of the interaction, one of those can look more dominant than the other. And the reason why that works in our business is that the medications apply to all those different diagnoses. And so what looks very chaotic actually makes sense from a treatment perspective, right? Because doctors aren't examining people for you, they're examining them for treatment, they're writing the records for treatment, and then when you apply them to the law, the fit isn't perfect all the time. So just to start there, and then when do you need an expert? I would suggest if anybody in the VA is claiming malingering, you need an expert. Right? Because malingering is a death knell for going further. And malingering is often misunderstood. Malingering is often understood as exaggeration, or as faking, or as lying. And malingering has a very specific diagnosis, and your expert can help you sort out that. And what I always give the example is, if you sprain your ankle on a Saturday night and go to the ED, emergency room, right, and you see a whole line of other people in front of you, and they ask you, how much does your ankle hurt? My guess is you're going to exaggerate a little bit, right? But the ankle is still damaged. So the exaggeration of symptoms does not mean that underneath that exaggeration there isn't a problem also. Okay? And there are good malingering assessments. Now, if your expert tells you that on the assessment they look like they're malingering, then you probably want a different expert who will give you what you want. No, and we do have those, right? Horrors of the Court. There's a whole book about that, who'll give you what you want, but you'll know where your weakness is. And you'll know what you're going to have to stay away from or be careful about. So even if your expert says, you know what, it's not holding together, and on the test, there was the tests are invalid, and the PTSD test is invalid, you'll know where your weaknesses are, and then maybe you just want to attack the record, not bring in a separate assessment that's really backing up the record. And records are pretty easy to attack because we all make mistakes on records as we go through. All right, so with malingering, you definitely need it. You also need it when the diagnoses are some imply a very particular kind of disorder that hems in how you think about it. So I think of PTSD as one that expects certain patterns of symptoms. Even though the more we know about PTSD, the more we know it can occur long after the trauma. It can look differently in men and women. There are many differences about that. So if you're seeing inconsistencies in the records that you're reviewing from the VA, you might need somebody to sort that out. And to give you an idea of why, even though they're inconsistent, they're all painting the same picture about an impairment. Now, you asked me, Margaret, to talk about the psychotic disorders a little bit, and that's on a flash drive that I don't have with me. It's still in the car. And and to talk about when did the psychosis start? So let me describe to you, and we can email you those slides. But a psychotic disorder is something that has either a long or relatively short prodrome. That is the early signs of it, before it's completely declared. And a psychotic disorder is the major brain disorder expressed in behavior and thought, because it is the most serious. It interferes with the capacity to tell the difference between what I'm thinking and what's going on outside. So a psychotic disorder is one that interferes with judgment, perception, memory, and decision-making. Right? And it does that in different levels or in different ways. If you've seen The Beautiful Mind, John Nash, a pretty good depiction. Actually, the first Beautiful Mind that Ron Howard really wanted was a Yale Law student who had a psychotic break while he was in Yale Law School, then went on to finish. And he was signed up, was in contract for a movie and a book. His name was Michael Laudor, Laudor. And then he killed his fiancée, who was an attorney in Prague. Went up to Cornell, was found on the gorge up there. But if you have a chance, Google and watch, you can see the series that the New York Times did long before he had done that problem, and you can see the description that in the beginning he was struggling, and he was very bright, and then he began to decline a little bit, but he wasn't diagnosed with schizophrenia at that point. It was just kind of a slide. It was fairly vague. So in the military, sometimes you see somebody coming in and they get promoted. And then suddenly they can't do the job. And then they kind of are a loner, or they get into these odd difficulties. You're going to see drug use, because the overlap between early schizophrenia and drug use is very high in every population. And the military has easy access, certainly, to drinking. Right? And then you begin to see more of a slide, and then maybe some arrests. And then they come out, and sometimes they come out because they're discharged under less than honorable conditions. They come out, and then they're diagnosed a year later or 2 years later. The question of where it started is a question that we don't handle well, because for us it's a ridiculous question. And here's why. Schizophrenia is something that we know is genetically connected. And where it started is sort of pick your time. It's hard to know. What we care about is when you treat it and how you treat it. But you need to know where were the early signs and how do you convince people of early signs. And there, the data that's going to be important are the military records that show a decline in function. Collateral, when the mom says, you know, he used to be so friendly, always had friends over, he came back and, you know, I don't recognize him. He started writing letters. Or if they're married, as one of our cases was, the woman would say, you know, he had these weird ideas about everybody. He was afraid that people from the outside were spying on us. that ISIS was really on base and they were lying about it. And he doesn't say that out loud to everyone, which is a misperception that the VA shouldn't have, because no psychiatrist believes somebody walks around with a neon sign saying, I'm slipping into schizophrenia. They don't. It's that vague failure of judgment and perception. And then when it is full-blown psychosis, that's when it's obvious to other people. So for example, if I were right now, I'm worried, am I putting too much together? Am I still rushing because I feel bad about being late? I'm thinking about my husband. All of that's going on in my head, and I recognize them as my thoughts, all of those. If I were psychotic, I would see you as kind of staring at me. And actually, you're taking the thoughts out, so I'm feeling really like I'm getting messed up. The thought feeling is a symptom. Or you're putting a thought in my head. You're laughing at me back there. You're laughing. And I can hear you now, and what I'm hearing is, you dumbass, they don't want to hear you. It's late. And so now, my fear becomes objectified outside. Now, in a bona fide psychosis, I'm not going to tell you that I'm thinking that, right? What I'm going to do is kind of withdraw and move away. And so those early signs really could be style, it could be something else. They're documented then, verified, when the diagnosis hits later. But you can see the start in the decline in function. So with Mr. Lauder, when he couldn't do Yale and failed the first semester, he didn't have his first psychotic break till later. That was a sign. This really smart kid who was really high up there now couldn't do the work that he could do just a little while before. And that's what psychotic process does. It robs you of the ability to maintain that kind of attention, concentration, processing. Right. So that's what you're going to look for if there's a psychotic disorder later, as to when did it start. Now, don't be put off by, well, he was using drugs. Drugs don't cause schizophrenia. They might enhance the symptoms and speed up the time they come out. They might do that, but they can't cause schizophrenia. Can they cause a drug-induced schizophrenia? No. They can cause drug-induced psychosis, but that goes away as soon as the drugs go away, or within a few weeks after. Schizophrenia is different. So that's what your expert can help you get a picture of. When they ask you for all those collateral records, I suggest giving them, right? Because without the collateral, they're going to be forced to speculate on what might have been there. And so collaterals are important. The DD-214, you can't do anything without it, right? That's going to be critical. Now, common challenges and red flags that you can pick up in the records from the VA are the variation in the disorders, when they're really wide variation. So you see one person diagnosing as schizophrenic, and then the other you say substance abuse disorder. That's too wide. Schizoaffective, schizophrenia, they go together. But one is saying he's really sick, and the other one's saying he's using drugs. So that wide variation really needs to be reconciled. And I would say another evaluation that does it. Drug and alcohol use. It's so easy to blame everything on drugs. And sometimes it is drugs. But a lot of times the drugs are one part of the story. Dual diagnosis in serious mental illness ranks about 90%. Because you're trying to fix it. Or you feel a relief of your anxiety, or so I don't hear your negative feedback to me in my head if I'm smoking a joint. It goes away. So that overlap is there. The problem is, the one thing you can test for is drugs. We have no blood tests for schizophrenia. None. There's no test that says absolutely schizophrenia. All we have is the behavioral pattern and the response to medication. If any of you took one dose of the antipsychotic, you'd be asleep right here today. So when you can give that much Risperdal, that much Haldol, that would put anybody without that brain disorder under the table for a week, you know you're on the pathway here. This is making a lot of good sense here. And that's what the treatment is like in psychiatry. It's sort of hit and miss because we don't have the measures or the markers that other medical specialties do. Functional decline with aggressive behavior. What do we mean by aggressive behavior? When I see a chart that says, or a record that says the guy was doing really well, and you know what? He wasn't even confined to base 1. He did really good. And now suddenly everything's falling apart. You want to say why? Because somebody who has an aggressive style should have been aggressive all along. That's what we see as style or personality versus the onset of a disorder. So you want to look at that in the charts. When did it start? What does it look like? And I always ask, can you get me the arrest record? Because I don't want to hear assault on a public safety officer. I want to see the record that says the guy was nuts. And when the police detained him, he spit at the police. That is very, very different than someone pulling a gun on an officer at a traffic stop, right? Which would be the same thing. So the diagnosis is in the details, in the context of how it happened. And again, as I mentioned, question of malingering. Anytime the VA says malingering, you really need to be able to question their own records. And that's what I like to do, cross-examine the VA records. So if somebody's been treated for 2 years in the Texas VA and then moves up here to the West Haven VA, and up here they say they're malingering, then you want to say, so you're saying any psychiatrist in Texas doesn't know what they're doing. It's essentially what you're saying, because schizophrenia doesn't go away. So why are you calling it malingering? So those are the kind of questions that we need to look at, and you might begin the process. All right. So I talked about how diagnoses are made, and I just want to say a few things about a few disorders. I just have a few minutes. But if you look at the diagnosis, this is from the DSM-5, so it's what we use. It's not a Bible, it's a guide. Look, life experiences. These are symptoms. Irritability, even aggression, is one of the symptoms you recognize for PTSD. So if it occurs, right, you need to know the broader context, because the diagnosis itself expects some of these to happen, right? And that happens actually in all of these. Traumatic brain injury, irritability, easy frustration, anxiety, right? So, and our new TBIs that are coming back are often percussive. And the problem with percussive injury is it's global in the brain. So if you're standing next to an IED and it goes off and you get thrown really hard, your entire brain gets shaken back and forth against what we call the vault, and it's hard. And so there isn't going to be a neat little place that a CAT scan will show, right, that says, oh, he got a gunshot wound, so the damage to the brain is right here. It's rather diffuse. And it's often at the capillary level. But we have 12 billion neurons. So a little bit of disturbance, you don't need a lot of bleed to cause a problem. And it shows up as this disorganization, irritability, inability to make decisions under stress. That kind of thing is related to the traumatic brain injury. One of the big problems now, you can't ask a person, were you unconscious? Anybody who says, yes, I remember being unconscious. No, not a good story. So if nobody took a record right after it, a person can recover. I mean, think of Gabby Giffords and how far the brain could recover with definitely an injury that we knew. So you have a little less of an injury, you can recover, but you have these problems. And you can see how, with these characteristics, couldn't you get arrested for? You could get arrested. Right? You could get in trouble on the base. You could suddenly now have a decline in function that the military sees as just bad behavior, when you were stellarly good behavior. So what you want to look at is the pattern. Why does somebody who was fine before suddenly not? And you have in the middle of it this potential cause. That's what you want your your expert to look at. Okay, and I just want to look at one other. Watch for personality disorders. They're enduring problems. Personality disorders can never be diagnosed in one session. Right? They can't be diagnosed in one session. Because have you ever had a bad day? And do you look the way you look when you're not having a bad day? I give a much more organized talk. I really do. So you can say she's a scattered speaker. She can't stay on her own notes. Right? And you would make a judgment about my pervasive ability over time based on one time. Well, that happens in a session. No, personality disorders should be held before you diagnose them. There are measures, but you want to see collateral. Personality disorders show up across situations. So we have seen a number of people diagnosed as borderline disorder or antisocial. Antisocial is the kiss of death, but the thing with antisocial is it has a lot of these things in it. Right? And so I always think a personality disorder should be the last thing that's ever diagnosed after you're sure you know everything else. And it should be over a long period of time. So that's the other thing you want to look at. I'm probably out of time. Do I have time for questions? Yes. Okay. And I'll send you the psychotic things that I mentioned. Yeah.
I have a client. I see where the employer indicates on 3 occasions poor judgment. And when the client applied for disability, the medical review board didn't decline. How do you reconcile something?
Well, it would. I think part of it is what's the pattern of poor judgment. All right. So a military situation.
Yes.
Okay. So let's take the. First of all, he takes the military vehicle that he's supposed to drive on base. He takes it off base, picks up some things, comes back. That's the first bad judgment. The second bad judgment is he comes in late, doesn't come back at the time from his. I'm making these up, right? So that kind of bad judgment could come from somebody who really doesn't give a damn about rules, right? But it depends how else he is. So if you focus on only the 3 bad judgments, you have no idea what context they're in. So supposing this is somebody who had been really high functioning all along, has something happened, and then this began. And if that's true, then instead of calling it bad judgment, you call it a symptom of something, right? Because you know people with bad judgment. There are a lot of people with bad judgment, and they just have them, and there's no psychiatric explanation. The only way you're going to know that is to look at patterns, right? And the pattern tells you if in basic, he was always in trouble. And then his first assignment, he was always in trouble. And he was in trouble in school. Then it's hard to say, yeah, this is a problem. But if you don't have that pattern, and that's the problem with looking at only the problem, you've got to put it in the context to really come up with a medical diagnosis.
Is that in the context too? The person having a nervous breakdown.
Oh, well then, nervous breakdowns and bad judgment go together. In fact, we define nervous breakdown by bad judgment, right? There is no diagnosis of nervous breakdown. There's no diagnosis. Right. So what we mean, we know what we mean. We mean the person falls apart. And so then, how did they fall apart? And it was a symptom of what? What was it a symptom of? Is what the question would be. How they fall apart, for example. Anything else? Yes.
How do you deal with the challenge of having someone who really did have something bad happen to them, but is just a jerk? They really are the guy who doesn't give a damn.
Yeah,
but they also have TBI.
That's a good point. And you know what? Psychiatrists don't like them either. All right. So here's the thing. One truth is people can go through bad events and not get PTSD. Right? Because it's the vulnerability and the type of event and when they come together. So he might have had bad things happen to him, but his life didn't change because of them. He was always a jerk. He was a jerk during and he's a jerk after is one where you're going to say, well, there's not much we can do. if the jerkiness, and what this is a very important lesson. A psychopath is never a jerk to your face. It's after they leave that you say, damn, he was really a jerk. Something going on in the news right now, the other imposter, right? He said he was the CIA agent. He actually got into the CIA. He's been doing a whole bunch of things, and they finally caught up to him. That's a true psychopath. He could convince people. So a real psychopath is never going to be a jerk to you. They're going to be really nice to you and convince you of their situation. So jerkiness needs to be analyzed. Does he fly off the handle when you talk to him? Is he sexually inappropriate? We call that disinhibited. Disinhibition occurs when the frontal lobe is damaged. It occurs, for example, in Alzheimer's, if you think of grandfathers who were suddenly doing things inappropriately to their granddaughters, and they never did before. And we say, well, their judgment's gone, right? So you need to analyze jerkiness and figure out. And then I would look for collateral. Is he a jerk everywhere? Or is it just when he's confronted and asked to remember what you're trying to build your case on? This happens in immigration too, immigration law. We need you to tell us why you were persecuted, and the person can't touch that because it causes too much anxiety. Could be for that. So describe jerkiness, exactly what it is. Now, lawyers know jerkiness, and you have to defend it anyway. I guess, because I've seen that. Then you might not want a medical evaluation that's just going to confirm what you know and then really looks bad because now you have data backing it up. Yeah.
So you said that there's some diagnoses that require multiple sessions, say with a professional. How do I know, or will the professional be able to know that if I need an expert and they meet with my client once? Will they say, actually, I need to meet with them 3 or 4 more times? Or?
Well, I'm going to turn to Margaret and the clinic a little bit, but in our work, we never see a person once. Because I always say you can never get the whole story. They tell you things, then you check collateral, you have to go back. But personality disorder can't be diagnosed except over time. And so if say you sent me somebody who had a diagnosis of antisocial personality from the VA, but he was also treated with antipsychotics, I'd want to look up a lot of collateral to see if I could support their diagnosis. And if I can support their diagnosis, then I can say, despite these other things, there is the antisocial, but there's something else, or there isn't. If I can't support their diagnosis, and I always start off, when you ask me to do a case, I always start off thinking your side's wrong. To be sure I cover what they're going to say first, and then move down, because if I don't know, if I can't see the basis for their argument, or don't look at it rather, if I don't look at it, I'm sitting there with a hole in my report. I've got to see how did they get to where they were. Does that help? Yes. But I would, and I know some of your experts around money and time, but they've got to sit with the person, and they've got to look at collateral, or you go in weak.
And this is exactly why we try to avoid having a competent pen exam, which is like a 45-minute exam, the only opinion, and why we really try to make sure that VA clinicians understand that they, as the treating person, they actually have all this background information. They're in the best position to do this opinion, even if it makes them feel a little squeamish. They're really doing their client a disservice if they just turn them over for this one-time, 45-minute thing and assume that that's going to be totally different.
It's not going to be. And watch, somebody can malinger and still be sick. So what's underneath the malingering is also important.
And I'm going to suggest that we do more questions after or by email. Thank you so much for coming.